Hello everybody, this is a recording of my paper just in case there is any technological issue. I thought it would be a sensible thing to do. So I'm really happy to have been asked to give this first paper in the excellent sounding conference. I look forward to hearing what everybody else has to say as well. So it's an honour to kick this off. My aim is to talk about a particular thing, but perhaps also to open up some themes which I can already see connecting with things that other people are going to talk about, which is absolutely not an excuse for having not the world's tightest conclusion at the end of this. But yes, it's deliberate. I'm trying to open up themes. So anyway, what my subject matter is here is the idea or the offence of mayhem, and a particular procedure to deal with that, the Appeal of Mayhem. So this is a kind of criminal procedure in English common law which exists from the medieval period onwards, and it relates to specific kinds of bodily harm. It has significant interest from a gender point of view, and that is my special theme in the paper. I want to take a little tiny excursus right at the start though to note that I'm conscious of the effect that the word mayhem has on modern audiences, even audiences predominantly of historians. And I think it rather chimes in with the whole popular culture of the medieval period as brutal and also somehow silly, because mayhem is not a word we take particularly seriously in modern English. It sounds, I don't know, like slightly amusing chaos, doesn't it? It does sometimes have a more general sense in medieval England than I'm going to be talking about, but it's certainly not ever humorous. And the main subject matter here is quite specific. It's a particular criminal procedure, the Appeal of Mayhem, dealing with a particular sort of non-fatal injury. And my big point is this is very interesting from a gender point of view, a masculinities point of view, and I suppose I've got an evangelical legal historian mission here as well. My mission to the historians, if you like, is that I think that it's a good example of the point of excavating legal doctrine itself, not just legal practice, but the doctrine itself and the process of its formation within the wider project that we're all engaged on of looking at gender and masculinities in historical perspective. So I'm going to proceed in the following way. First of all, I want to give a general overview of the concept and the idea of the Appeal of Mayhem. And then I want to set out a kind of tentative origin story and a life story, or an early life story of this particular form of action and this concept, which probably sounds a bit basic. Surely somebody should have done that, but no, they haven't. They really haven't. And I think there are significant masculinities implications in the way that this thing arose. I will do a little of the final thing on my list here, but probably minimise it. It's impossible for a law-based academic not to say a little bit about the later development of all of this and the ramifications it actually still has in parts of criminal law. So I want to say a little bit about the way in which legal historical scholarship and modern law have treated this area, and because that, in fact, also has significant masculinities implications. So I'm going to try to stick mostly with the medieval stuff here, because I think that's enough for one paper or one book chapter, if that's where we're going to go with this. But I'm actually now also thinking about the possibility of writing a book, a longue durée treatment of this, if I can find any mad publisher who would be interested in doing that. So I'm interested in talking to people about that as well. Time to start thinking then about mayhem, and specifically about the Appeal of Mayhem, a particular form of action in the English common law. I think it's well approached through a particular example. So here's a reasonably full example from a later 14th century plea roll, by which time the Appeal of Mayhem is certainly well established. So this comes from a record from Trinity Term 1367, King's Bench plea roll. And it's not particularly a leading case in any way, it's just that it's quite a nice full record, and I think it brings out some of the aspects which will be of interest. So this is the case of William Dekon and Alexander Hert, Mason. And the allegation by William was that he said, "I was in the peace of God and the Lord King in London, in the parish of St Dunstan in the east, in the ward of the Tower of London, on Thursday, the feast of St Matthew the Apostle, year 36 of the current king, at the hour of Vespers, and Alexander came feloniously as a felon of the Lord King, insidiando, and with premeditated assault," so he's lying in wait and assaulting. This is all against the peace of the king and against his crown and dignity. And Alexander hit William with a certain knife called a basilar on his left arm and on the elbow of the said arm. And the result of that was that the veins and the nerves of that arm were restricted, injured, and destroyed, essentially, so that he lost the use, the force and the help, but the use will do as a translation, won't it, of the said arm. And so Alexander, putting all this together, feloniously maimed William. Mayhem avit is the verb that's used in Latin, sort of comes through French into Latin, I guess. And Alexander, it continues in the way that these things frequently continue. Alexander fled at once, William pursued him, and they're both ready to prove it as the court directs. Alexander tries a self-defense plea, saying that William was attacking him, trying to kill him, but that doesn't work. The jury don't buy it. The jury decide that Alexander did, in fact, maim William as per William's appeal, and that was to William's damage 10 marks. Interesting from a kind of medical point of view rather than a masculinities point of view, I suppose, is that the court then inspects the injury and decides that it's been undervalued, essentially. William was gravely and hugely maimed, graviter et enormiter maimatum, and so they raised the compensation. They put another £20 on top of the 10 marks, and William comes and acknowledges later on that Alexander has in fact paid him this money, though that confirmation doesn't come until 1371, so perhaps it was difficult to get Alexander to stump up. There was also a fine to the king. So as far as this as an example of something bigger is concerned, points to note are, first of all, it's an individual prosecution, so that's what an appeal is in this context. It's an individually initiated prosecution. The subject matter is non-fatal injury. It's construed as something against the king and against the individual, formally speaking at least. It's tried by jury, and the outcome in case of success is financial. Right, if I can just park William and Alexander for a minute, we will come back to them. I want to take a slight legal scholar, what might seem like a detour, but there is a point to this, for a few minutes. I'm going to go into that well-known medieval period, the 1990s, with a case which is incredibly familiar to undergraduate students of criminal law, at least in England and Wales, but there's no reason why people outside that group would know about it. So this is from a case called Brown, which is about gay S&M sex in the northwest of England. And the legal point is whether a person who is accused of non-fatal injuries can defend himself by saying that the other person, the victim, as it were, had in fact consented to the infliction of those injuries. So, all very interesting. Perhaps what is the link? Well, the link is, I'm not going to be cheap enough to go into some of the dungeon imagery, which is sort of medievalism, which comes in some of the commentary and to an extent the case itself here. The point is a little bit more involved than that. So these are offences, the offences which were alleged and were in fact convicted, against a modern-ish piece of legislation, the Offences Against the Person Act 1861, but argument was made relating to mayhem, to this older offence. Mayhem comes up to a great extent because the classic statements about non-fatal injuries and consent from Victorian and further back early modern jurists tended to put mayhem in the foreground, making the point that while consent might work as a defence for slight injury, one could not consent to a mayhem, or that wouldn't work as a defence. So in the process of argument in Brown, there's some exposition of what mayhem was thought to mean or thought to have meant. I've got a couple of quotes here from two of the judges in the case. So Lord Templeman said that a mayhem is a bodily harm whereby a man was deprived of the use of any member of his body which he needed to use in order to fight. The act of mayhem was unlawful because the king was deprived of the services of an able-bodied citizen for the defence of the realm. Violence which maimed was unlawful despite consent to the activity which produced the maiming. So obviously in the context of the case they're interested in that last bit, the self-maim or consent to maim issue. But the rest of it is also quite interesting and to the point for us. And to a relatively similar effect, Lord Mustill talked about maim as such a hurt of any part of a man's body whereby he's rendered less able in fighting either to defend himself or to annoy his adversary. I do like that word, annoy, which is from an 18th century criminal law textbook, Hawkins's Pleas of the Crown, though in typical lawyer fashion he doesn't go to the original, as you might do if you're a historian. He goes to the most recent version of Hawkins's Pleas of the Crown, which is from the early 19th century. So they're saying broadly similar things. What do we get? What can we boil down from those two explanations of what mayhem was? So we're talking about men specifically. We're talking about members. It's injury to members, which is not necessarily sex or gendered, though it's interesting that we tend to use it in that way now, don't we? We don't talk about female members, we talk about male members. So there's more on specific body parts coming up. It focuses our minds onto fighting. Just what kind of fighting is perhaps different in between the two judges. I don't think for their purposes it particularly mattered, but that's something which certainly has male, masculine overtones. And we like an exception, don't we? But I think it's not terribly controversial to say that fighting was for centuries perceived as a male activity, and particularly the kind of fighting which would bring into play talk about defence of the realm, so army type fighting. And both of them tell us that consent doesn't give us defence, so self-maim or consent to maim is also problematic. So these modern statements, I mean, they're certainly not wrong as reflections of the law of the past, but they don't quite capture the nature or the trajectory of the form of procedure that I'm talking about here, nor do they acknowledge some of the complications which come in when you look at how the law was actually understood and how it was actually used. It's actually quite informative looking at stuff like this on how lawyers use historical sources, how they look at the law of the past. So they're going through the treatise textbook tradition, and that's not always the best source if you actually want accurate history. But any lawyer or judge who wanted to look up the legal history on this would be a bit disappointed, I think, at the paucity of scholarship that there is on mayhem. It's not non-existent, but there's not very much. In particular, the classical canonical legal historians in the kind of Maitland, Milsom, Baker bloodline haven't been very interested in this at all. So Pollock and Maitland, the great work on medieval English law, mentions mayhem, but I guess this sort of sums it up. We have a long passage before this statement on homicide, and then we get to just, of the other felonies, there's much less to be said, and there's a short discussion of wounding, mayhem and imprisonment on 2 pages. So the treatment's quite perfunctory, despite the fact that actually some of the key developments I'm going to talk about take place squarely within the Pollock and Maitland period. And in the other kind of canonical works, Baker, Introduction to English Legal History, and Milsom, there's very, very little. Little in Baker, nothing at all in the notorious chapter on criminal law in Historical Foundations of Common Law of SFC Milsom. So why is it being neglected in legal history? Well, it's not surprising they've not been interested in the gendered bits of it that I'm going to talk about, but maybe it's quite interesting that they they haven't been interested in it at all. And partly that's the result of a disdain for crime. So if you look at the balance of these books, they say a lot less about crime than they do about other things, land law and tort contract, for example. Partly it's about the backward-looking imposition of sort of later categories on the past, which legal historians tend to engage in. So mayhem sits somewhere between felony, crime, and tort. And so sometimes it gets missed out of both of those stories. But I think skating over it means that classical legal historians have left a gap in their treatment of something they definitely are interested in, which is the lawyers of the past and their ideas. Because the lawyers of the past were certainly interested in mayhem. So that it comes up in quite a lot of reports from the 13th century onwards. So that even in that year of Dekon and Hert, there are 4 cases in the yearbooks on mayhem. Or 4 reports. They might not be entirely separate cases. And a quick, computer search of the SIPE database tells us that there are 77 cases for mayhem. So it's not something people were ignoring in the medieval period. And certainly it's a staple in later treatises as well, and works of legal scholarship like Hawkins that was referred to in that case. So it's a strange gap in many ways. And it's high time it was filled by me. So what have I found? How did the Appeal of Mayhem begin, and what is its connection with Masculinities? Well, the medieval appeal and the concept of mayhem didn't come to occupy entirely empty juridical space. There is a prehistory for activity in this area. In fact, there is prehistory on a European basis. For legal responses to non-fatal injury. So there's Roman law on this point as far back as the 12 tables and thereafter, so throughout the kind of recorded history of Roman law. There are also early medieval legal sources from many different Western European jurisdictions with a characteristic compensation tariff, which has received quite a lot of scholarly attention. Including attention on its gender aspects, because the lists of injuries and appropriate compensation or starting positions for negotiation in financial terms were gendered, as well as being split up along various other lines. So there's clearly some relationship between all of this. I'm not saying that mayhem comes out of nowhere, but it's not entirely clear that there's a direct relationship between mayhem and these much earlier concepts. I think we're best looking post-conquest, post-Norman conquest in the common law for this. So when do we begin to see mayhem in England? Well, we still seem to be in sort of compensation tariff mode in the earlier 12th century. So the Leges Henrici Primi, that non-official collection of laws of the early 12th century, still looks very much like a compensation tariff. There's no listing of mayhem in measures of Henry II, like the Excise of Clarendon and the Excise of Northampton. But at the end of that same century, at the end of the 12th century, there's evidence of something called mayhem, but it's a differently shaped mode of intervention. And I think this is the ancestor of the Appeal of Mayhem. So mayhem, a word of French origin, comes into view in Glanville, the treatise of the late 1180s. It does so in a definitively masculine fighting context, though it's not the idea that we saw from that modern case earlier on of the loss of general fighting ability or the loss to the king of a fighting man, as later descriptions would have it, and that loss to the king business is probably early modern, I think. It's a more specific judicial context in relation to proof. And it's being used as what modern lawyers would call a shield, not a sword. That is to say, it's being used as a defence rather than an independent cause of action. So here it comes in Glanville, and it tells us that the accused may declinare, may refuse trial by battle in felonies, in criminal pleas, for various reasons, age, young or too old, but also serious injury, mayhem. and there's some discussion of what mayhem is: a broken bone, injury to the skull by cut or bruise. So in those sorts of circumstances, it's legitimate for a person to ask for a different mode of proof than trial by battle. And this happens. There are a number of these cases where people say, I can't fight a battle because I'm maimed. So in English common law, the word mayhem does have a close connection to something very specific: the ability to fight a judicial duel from this early point. And it is explicitly gendered or logically gendered because battle is a mode of proof which is only for men in the English common law. A move from seeing mayhem as a way of getting out of trial by battle, so I would call that shield, to seeing it as an independent cause of action seems to occur in the early 13th century. So there's no kind of definitive decision that this shall be so, but that seems to be when we can see it happening. So this case on the slide here shows a bit of a transitional moment. It's mostly about mayhem as a shield, but mayhem is also part of the complaint itself. So this is a case from Bracton's notebook, a collection of cases from Easter term 1225. So we have Walter appealing Simon, saying that Simon has beaten him up, hit him over the head with a candlestick, but also robbed him. So it's a sort of mixed allegation. And Walter says, as a result of this, obviously, I'm a maimed man. So although Simon wants the thing to be tried by battle, Walter says, no, I'm maimed, I can't do battle. And it's viewed, his wound is viewed, and it's found that he is maimed, so the duel doesn't lie. There's more to this case than that, actually. It's quite a nasty case in other respects, but that's the important point from our point of view. So both a shield and a sword, I suppose, in that situation, though we haven't got it as absolutely an independent cause of action because it's rolled up with the robbery as well. We could probably say that Bracton marks the crossover point, the great 13th century treatise, because it includes both mayhem as an excuse from trial by battle. Also, it includes appeal of wounding and mayhem, so mayhem as a cause of action. So it's got both things, and it links the two in the bit there. It may be said to be mayhem when one is rendered incapable of fighting, especially by him whom he is appealing. So it's about cause of action, but it's also focused on a particular dispute and how it will be proved, I think. And as I said, it also has the cause of action mayhem. It has appeal of wounding and mayhem in the treatise as well. By the time we get to the late 13th century, to the treatise Plea, which owes a lot to Bracton, but it's not exactly the same, this emphasises the mayhem as a cause of action thing as one of the criminal wrongs which do not entail death. So it's seeing it in relatively modern sounding terms as basically a non-fatal injury and a non-capital felony. So it's become a category of wrong, grounding in appeal, rather than an excuse for trial to get out of trial by battle. But it retains conceptual scar tissue from its earlier incarnation. So theoretical works really do remain wedded to the idea that it's something to do with fighting men, not a general remedy. And some of the gender implications, which we'll discuss in specific types of mayhem, also, I think, stem from this. And it has to be said that this fighting business is a distinct common law pattern. It's not really comparable to either the compensation tariffs or the things that are happening in related Western European jurisdictions. So that is quite interesting from the point of view of specifically English masculinity, I suppose. So now to what this sword concept of mayhem was, and there's certainly some masculinities content here. So it's anachronistic, of course, to expect a strict definition of a medieval offence, but mayhem always did have boundaries in terms of the injury covered. There's no statutory or official list, but treatises show some information. They've got two approaches, I think, to answering the question, what is mayhem? Either they give a general definition of the sorts of injuries which count, or else they list specific injuries. Taking first the kind of general definitions, these very much focus on fighting. So it's a hangover from that earlier idea of trial by battle, almost certainly, isn't it? So we've got injuries which render people incapable of fighting. So inutilis ad pugnandum, as the Bracton version has it, and the French versions, they're weaker, they're plus faible à combattre for Britain, and they're enfeebled. Again, they're less powerful in terms of fighting as far as the mirror of justice is concerned. Kind of interestingly, Bracton contrasts mayhem, which is something functional and to do with fighting, and disfigurement. So things which are purely cosmetic aren't mayhems. And this rather points up a difference from the compensation tariff world of prior to this period, but also which still persisted in some places, in Wales, for example. I just want to say, I'm kind of assuming, aren't I, that fighting and men go together, and clearly that's the case with regard to trial by battle. It simply is, men do it this way, women do it that way. It's a really black, white, stark distinction. We could talk a bit more, couldn't we, about fighting and gender, I'm sure, but presumably it's uncontroversial that there are multiple connections between fighting, particularly organised fighting, which would result in, or practiced fighting with weapons of the sort which would result in the types of injuries that we're talking about in mayhem, and masculinity. I remind myself of the fact that there's this interweaving of men and fighting and weapons, which goes as far as kind of anatomizing, masculinizing the weapon itself. So what we have on the screen there is a thing called a bullock-hafted dagger. You can probably see why it was called that. The Victorians later cleaned it up and called it a kidney dagger, but this is one of the sort of standard weapons, sidearms, if you like, of the time. And clearly, I'm not saying that medieval women didn't fight. Of course they did. There are many accounts of them fighting. But treatments of fighting with weapons in the medieval and early modern period assume this to be a male pastime. So I don't think it's out of order to talk about this as a masculinity matter. That's the general definition idea then. Related to it, kind of perhaps expanding upon it, are the lists of examples that we see in treatises. So listing of the sort of injury which counts as mayhem. The mature definition of mayhem, or the later definition of mayhem, comes to focus on the idea of a member. It's about chopping off members, a part of the body which seems to be, I guess, discrete, separate or separable. Early lists are not quite as focused on this. Partly they're about members, but not entirely. So I've put Bracton's list up there. It's not utterly different from lists that exist in other treatises. It's a reasonable example and a reasonably short example. So he includes broken bones, crippling of sinews, whatever that means exactly, strange ones like making crooked of fingers, and various amputations. I'm going to pull out for discussion two particular entries on this list, so teeth and castration as well. But let me just point out as well that it does make it clear that there's a distinction between what counts as mayhem and what counts as disfigurement. So mayhem is all about function, I suppose, and disfigurement doesn't feature. And that's quite interesting in that that's rather a difference from some of the other systems and earlier systems in England as well. So we don't have so much focus on honour through disfigurement. What we're thinking about is function, fighting function. Anyway, teeth and testicles. I find this particularly interesting. And that was a strange sentence, wasn't it? Why are these clearly thought to come within fighting-based mayhem, and what does it indicate to us? Well, the teeth bit is quite interesting because it's really quite common to make this distinction between incisors and molars or grinders. So front teeth as opposed to back teeth. And I suppose my only observation on that is it suggests a kind of low-down, dirty method of fighting is what's in people's mind. And I do find that quite interesting. It connects up in my mind with a quite well-known account of trial by battle in the 15th century involving biting, but it might make other connections in your minds. Testicles. Okay, we've got to go there. So these feature in compensation tariffs as well. Compensation tariffs can be quite long. So, for example, the Doom Book of Alfred includes testicles, but they are considered in reproductive capacity and not specifically this testicles fighting link, which is quite interesting, isn't it? It's not, none of these, they're very short things really. They don't make explicit why exactly or how exactly the two things link together. I mean, of course, in the immediate aftermath of castration, you wouldn't be terribly good at fighting, I imagine, but it's very interesting to try and track the sort of conceptual link which is being made here. So I guess we're seeing testicles as a sort of locus of courage, of strength, etc. And maybe this is all connected with animal husbandry, observation of animals. So the castration of animals is thought to make them more docile, perhaps less inclined to fight. Perhaps that's the link. Medieval medical discussions of the effects of castrations don't really deal directly with fighting capacity, though they may mention effeminacy. Just throw into the mix though, there are some famous ancient military eunuchs who would not have been wholly unknown to the learned community of the medieval period. So it's a difficult one to disentangle. But certainly later legal explanations make a direct link. Castration is supposed to debilitate and render unwarlike, says Joseph Chitty in the early 19th century in the criminal law textbook. I have quotations from the early 20th century which understand castration as changing the entire physical character of the individual, diminishing bodily vigour or courage, or rendering somebody, again, as with the medieval period, effeminate. So I think that's something to ponder for scholars of masculinity as well. This explicit insistence that castration counts as mayhem. How do those lists compare then with the law reports that we have and with plea rolls in terms of which body parts we're talking about in mayhem cases? Well, I'd say that the cases themselves, as we find them in the reports of lawyers and the records of the central courts, have a lot less focus on some parts, and in particular testicles. There's not a great deal of castration going on in the cases. Hands and fingers predominate, and adjacently I find a shoulder, a leg, one case on an eye, one on an eye and tongue, and the records are similar. So some of that seems reasonably removed from real and necessary connection to fighting, and the lists of injury connected to that. But the importance of fighting does still sometimes come up in lawyers' discussion. So a 1367 report suggests that fighting is still in the sort of an important place in lawyers' thinking on mayhem. So this is a case in which a man is hit in the head and in the arm, and there's discussion about whether perhaps the head injury meant that he couldn't protect his arm. So the arm injury is seen as the central mayhem, and the head injury is a little more difficult to classify as far as that case is concerned. I'm simplifying, it's a bit more involved than that, but it's interesting, I think. Perhaps it signals a kind of settling down to a different centre of this offence. So the loss of members idea, rather than just damage to fighting ability. So it's specifically, I suppose, chopping something off as opposed to damaging it. So apparently you would think that the one way of reading that case was that it's not obvious that a head injury would be a mayhem in and of itself. And so perhaps we're seeing an attenuation of the fighting aspect of mayhem in the 14th century and its construction in relation to the fighting man. So as I say, if it was all about loss of fighting power, a head wound would sensibly be covered. And non-lopping injuries, if you like, would do certainly appear in the lists in treatises. Putting a bit of chronology back into the picture, the treatises are a bit earlier. So the lists that I've looked at are 13th century, whereas much of the yearbook material is 14th and 15th century. So perhaps we're seeing a move away over time from the fighting idea. Another way in which we seem to move away from the idea of the original form of mayhem in relation to trial by battle is to do with women. So the Brown definition, which follows accounts of mayhem in especially 19th century treatises, emphasises its association with the male body. Yet the situation was not so clear-cut, even though one of the leading figures in criminal law in the 20th century, Glanville Williams, in The Sanctity of Life, said the law of mayhem seems historically to have had no application to women. And you would think so from the treatise definitions, actually. Indeed, as well, all early trial by battle mayhem cases were male, as one would expect. And it's also true that the vast majority of plaintiffs and defendants in plea roll mayhem appeals were male as well. But there do seem to be a number of cases in which it's just uncontroversial that mayhem applies to a woman's injuries. There are some early cases which are a little bit borderline, so cases in which women are alleging mayhem and something else. So there's a case in 1212 in which a woman brings an appeal of mayhem and robbery. But by the 14th century, damage to women's body on its own seems unproblematically to be brought as an appeal of mayhem. So there's copious litigation on a rather unpleasant incident involving a woman called Agnes de Holdenby, in which she had her eyes and tongue removed. There's lots of litigation of various sorts, but amongst that there are appeals of mayhem, and there's no sign that that's regarded as out of order. She seems to get some money from it. And this is confirmed in common lawyers' sources, one from later in the 14th century, Stratton and Swanland, which is quite a famous medical negligence sort of case, is mostly about what we would now call tort contract. But in passing, it's said that the woman who is damaged by the query negligent behaviour of a doctor could actually have brought an appeal of mayhem instead. So that's confirmation, I think, that this is uncontroversial. And there are other cases as well in the yearbooks and in law reports thereafter. The last thing I wanted to mention, and something which is interesting in and of itself, but also because it brings up a couple of masculinities points, is the consequences of success in the appeal of mayhem. So if we go back to Dekon and Hert, the outcome there was compensation plus financial penalty, and that was standard at that period and later on. But there is an interesting eagerness in reports of cases and in some treatises to mention that what should really happen is something a bit different, is the lex talionis, the member for member idea. So if you chop off my foot, I get to chop your foot off, or your foot will be chopped off. And that's commonly trotted out in reports. So we get this distinction between the proper or the allegedly traditional consequence, which is member for member, and financial satisfaction plus fine to the king, which is what's happening now. I actually have my doubts as to whether the lex talionis ever was, in fact, performed in the Appeal of Mayhem, but let's leave that to one side. It's certainly part of the story and something people thought about. And from a gender perspective, it's really quite interesting in that there is a snippet in the treatise Britain, so late 13th century treatise, that thinks about this quite deeply and sees a problem with one possible mayhem. If you remember on the list that they're quite concerned about castration. And there's a discussion of, well, what happens if it's a woman who castrates a man? What do you do then if you're working in a lex talionis member for member kind of regime. And the answer comes to be that that the woman's hand will be chopped off because that's the thing with which she did it. But it's not. That's not quite lex talionis in the way that other mayhems would be dealt with. So it's quite interesting, first of all, that they're thinking about gender as a problem, I suppose, but also in that they're clearly obsessed with castration, and as the plea rolls seem to suggest, that's not one of the most common kinds of mayhem. So it's actually all about hands and fingers and arms, but Britain wants to know about castration. So that seemed to me interesting anyway. Okay, it's time for a coda and concluding thoughts. I end this in the later medieval period, but mayhem didn't end at that point. The appeal remains a possibility until 1819. The concept lives on in a sense even now. Though his knowledge of what the offence itself involved is patchy, lawyers have been contented with rather a simple idea of mayhem. It's all about men, members and fighting. It's much richer, more engagingly complex when you draw in evidence of law reports and plea rolls, as well as looking at treatises more carefully. And when you see the trajectory through mayhem as a shield plea to mayhem as a sword as an independent cause of action and its definition. So I've got no time to join the medieval and the modern really, but that's not to say that interesting things don't happen in what I'm aware I'm treating as flyover centuries of the early modern period. There are definitely some more interesting expansive ideas going on of what the harm, the damage in mayhem is understood to be, broadening it out to something more public, and in some cases beyond the fighting defence idea to include economics, for example. So there are statements, as in Poulton, which talk about weakening somebody and depriving him of an ability to earn his own living, thus damaging the Commonwealth. There's statutory expansion which brings in more disfiguring things than functionally damaging things. And there are some cases, some reported cases which call an injury mayhem, but then they talk about damage to the person's trade rather than their fighting ability. So I think it's fair to say that the next important thing that happens is that the mayhem fighting link is reinforced by a focus on deliberate self-harm, and especially because it's considered in the military context, people attempting to get out of military service by injuring themselves or agreeing to be injured. So that's what takes us back to men fighting and members. And so with that in mind, lawyers forget that this ever had a tendency to some degree of conceptual expansion, greater gender fluidity apart from anything else, if you like. And they pin it back to men members fighting. I'd say it has a lot more to offer than that for the study of masculinities and gender in historical perspective. To summarise it, the development of mayhem, almost exclusively by men, mirrors so many things I'm sure we're going to be talking about with regard to gender and masculinity. So it sits there on the borderline between certainty and uncertainty. There's apparent certainty that it seems to be built around men, and then on further investigation it becomes a bit more complex, doesn't it? You've got the shield and sword switch, which has a difference in terms of what you'd be talking about. Is it about men only or is it not? Well, the statements suggest that it is, treatise statements, but then cases show women recovering, women certainly not being challenged in bringing an appeal of mayhem. Is it about personal bodily harm? Is it about men's bodies? Or is it about damage to the king, the public, and so on, and what sort of damage? So there's a lot that I think we'll be picking up later in this conference. And finally, just on this particular subject, I just wanted to say I really find it curious and interesting that something that begins with paradigmatically masculine, use the anachronistic words, heterosexual, butch, trial by battle, and fighting, ends up playing a part in areas which are massively non-traditional in terms of masculinity. So the case of Brown is about gay S&M. And we see this coming up elsewhere in consent to surgery of various kinds, up to and including gender reassignment surgery. So it is fascinating. It speaks to both the endless fascination of legal history, I think, and to, ready for the cheesy ending, the appeal of Mayhem. Thank you very much.